Over the last few weeks we've heard a lot about React World, a new creative project created by the Fine brothers, Rafi and Benny Fine, the masterminds behind the YouTube channel React and its shows like Teens React and Elders React. In the announcement video, the project was presented as a way for the brothers to license out their Fine Brothers Entertainment brand names to anyone who wanted to make their own versions of the shows. In return for cut of the revenue, of course, it is only under license. In addition to the show names and associated stuff, the license holder would also receive aid from the brothers and their network to reach their audience. Towards the end of the announcement, the brothers said the thing that started the whole debate. Part of why we believe this initiative is important is due to witnessing many creators, ourselves included, having their shows and formats blatantly stolen by companies and people both online and on television, and we implore people to not support those companies and channels. This comment made people feel like the brothers wanted to bring the entire concept of reaction videos to a halt, leaving their show as the last one standing. What didn't help was that they had earlier made stabs at other shows and popular TV personalities like Ellen DeGeneres for having done reaction shows and not involved them. Moments after the video was put up, Fullscreen Inc., the multi-channel network the brothers work under, filed several DMCA takedown notices towards several YouTube channels that did reaction videos. This, combined with their earlier stabs, made people think that the brothers were working with Fullscreen to throw their legal team around, furthering the idea that they wanted to last man stand their show and shut down all other React channels. This led to close to 500,000 subscribers leaving the channel in a matter of days. In response, only 5 days after the announcement video was published, the brothers shut down the React World project, removed all videos mentioning it from their channels, and made a call to withdraw their trademark claims, seemingly as a way to calm people down through a maximum bailout strategy. The Fine brothers have been in the process of trademarking their show names for some time, and the ones that they already have won't be going away. They're also most likely to continue trademarking the rest of their shows on their channels, as they are legally allowed to do. It's their shows on their channels. But with them acting the way that they did, most people will feel edgy towards them and their other intentions. Throwing your legal weight around, especially on YouTube, is something you can't take back. This is why most of the subscribers they lost won't be coming back just because they cancelled their project. The saving grace and why they most likely bailed out so hard was to try and stem the tide, so the rate of lost subscribers is probably going to slow. Their hope is that the internet will just move on to the next controversy. On the internet, all will be not forgiven, but forgotten. But there might be another reason they dropped their claims. The brothers could actually be in a legal bind for having used DMCAs to file takedowns against the channels during the ruckus. From a legal standpoint, a trademark is very different from copyright. The main way is as creative protection. Copyrights are placed on every creative work, regardless of the person's status, meaning it can't be copied by anyone. A trademark is protection of trade or likeness which you have to apply for. For example, a publisher publishes under copyright but protects its name and logo through trademarks. EA publishes games under copyright, but the EA name and logo are trademarked so no one else can call themselves EA. It's a way to protect your reputation from the deviousness of outsiders and competitors. Another more subtle way is that you don't need to go through a court to file a DMCA takedown notice, but you do need to go through the courts to file a trademark infringement takedown notice. Legally, trademarks are more complex and harder to define than copyrights. A good example of where the lines are is the case CrossFit Inc. vs Alves. Janine Alves created a blog on Blogspot named CrossFit Mama, now largely unused but still remaining crossfitmama.blogspot.co.uk. It was just a blog to chart her progress through a version of the CrossFit exercise program. When she created a Facebook page for her blog, the company behind CrossFit, CrossFit Inc., filed a DMCA takedown notice to Facebook ordering the page be struck. Facebook didn't enforce the notice, so CrossFit escalated the matter. They took Alves to court. Alves counterclaimed and said that the wording of the DMCA means it can't be used to enforce trademarks, only copyrights. So since the name CrossFit cannot be copyrighted and only trademarked, this must be a trademark issue, meaning that the DMC takedown notice was a misrepresentation of the act, and so false. If true, this would be a big deal, as the DMCA has a section just for the misuse of the act. It states,
any person who knowingly materially misrepresents under this section 1, that material or activity is infringing, or 2, that material or activity was removed or disabled by mistake or misidentification, shall be liable for any damages, including court and attorney's fees, incurred by the alleged infringer, by any copyright owner or copyright owner's authorized licensee, or by a service provider who is injured by such misrepresentation as a result of the service provider relying relying upon such misrepresentation in removing or disabling access to the material or activity claimed to be infringing, or in replacing the removed material or ceasing to disable access to it.
The DMCA was created to speed up copyright violation takedown notices, as they were fairly uncomplicated when compared to trademark violations. The claimant files a complaint with the publishing platform. The platform can decide whether or not the claim is true. The platform itself needs no legal expertise at all to do this. If the claimant or claimee feels that the decision was wrong, they can go through the court to get it decided. This is why on sites like YouTube you can counterclaim copyright notices without getting a lawyer or the courts involved. But as the section states, if you file a DMCA takedown notice and do so falsely, knowing that a DMCA doesn't cover what you're trying to take down, or knowing that you're wrong, you may be liable for any damages, including incurred legal fees and or loss of income. This is why YouTube has that tick box when you counterclaim, saying that you know all the information of the counterclaim is true. If it's not, you may find yourself in court for misrepresentation. The interesting part of the CrossFit v Alves case is that, for the part involving the DMC notice at least, could be a case of misrepresentation. The DMCA isn't used for trademark law, it's used for copyrights. When Alves filed her counterclaim, CrossFit wanted it struck out, saying it had no bearing. The court thought otherwise. The court sided with Alves, and the counterclaim was allowed. For the foregoing reasons, CrossFit's motion to dismiss is granted in part and denied in part. Alves' counterclaim for declaratory relief remains undisturbed. Her counterclaims for violations of the UCL and the Lanham Act are dismissed with leave to amend. Alves shall file an amended pleading within 30 days of the signature date of this order. Failure to do so may result in dismissal with prejudice of her UCL and Lanham Act counterclaims. To explain, Alves' counterclaim was that the DMC notice was unfounded, was allowed, but she would still have to fight a legal case against CrossFit, but this time purely in a court of trademark law. The American Bar Association said of the case, of particular interest, one of the grounds for the defendant's declaratory judgment counterclaim was that the plaintiff improperly employed the DMCA. The court refused to dismiss the counterclaim because, while Facebook may have been willing to remove the Facebook page on the basis of trademark infringement, by issuing a DMCA takedown notice, the plaintiff plausibly violated the terms of the DMCA, pursuant to Section 512F. So what the hell does this mean in relation to the Fine Brothers? This means that every video the Fine Brothers or their network filed a DMCA takedown notice against that does not have any content from the Fine Brothers could be a misrepresented claim. And if any of the creators of these videos lost any income due to that takedown, the brothers and or Fullscreen can be liable for loss of income and, in extreme cases, damages. By dropping the claims and bailing out as hard as they could, the brothers might be hoping that these creators will be too relieved with the fracas now all over to look into it any further. They want everyone involved to move on and forget, but this is the internet and all will not be forgiven, but will most likely be forgotten.